Hello and welcome. This is Attorney Jumoke from Ivy Law Office LLC, your trusted estate planning attorney. You're welcome to today's episode of Ivy Law TV Live. Hope you had a good day so far. Today we'll be speaking about wills versus trust. Which one do you need? We have a lot of clients that have come to us at different times and they were like, what do I really need to have between a will and a trust? And a lot of people don't even know what they need, but they'll say, I need a will, because that's the most popular planning document that a lot of people are aware of. I want to talk about how you determine whether you need a will or a trust. In this matter today, we'll be speaking about the revocable living trust. Number one, do you have assets? And if I'm talking about assets, if you have a modest amount of assets, which probably is under $100,000, maybe you'll be speaking about having only a will, or in many cases, I say if you have assets over $50,000, you may be talking about wanting a living trust. And this is why I say so. In Maryland, a small estate for one person is $50,000 and below. So if you have a small estate, then you may think about having a will, because a will will definitely have, you'll be able to make decisions about who will help you administer your estate, and maybe there isn't so much to give, or maybe the person does not have enough assets to protect with a living trust. So that's number one. If you have a home, most likely you have an asset of $100,000, and you may be looking at having a revocable living trust in that light. Secondly, which is part of what I've spoken about, if you have a home or a real estate, you may look at having a living trust in place, because if you have a living trust, then you're going to be saving a lot of probate taxes at the end of the day. If you have just a will, then your um, personal representative or successor trustee will have to pay a lot after you've gone into probate costs, which at this point you may want to preserve if you're looking at preserving your family assets or avoiding probate. Thirdly, do you have minor children? If you have minor children, then rather than have just a will, you want to have a trust. A living trust provides you with some better benefits, because you can make more advanced level of plannings on how to protect the assets that your young children are going to get in the future. First of all, a lot of minor children cannot have the inheritances or the assets you give to them, if you pass away and they're still under 18. And when they turn 18, then they're going to be having those assets outrightly. So, for example, if you have a life insurance and you give it to your child, the child cannot make use of that money until, and it's not going to be given to them until they turn 18. And after the child turns 18, they're going to have the money outrightly. So, let's say it's $500,000. You're looking at giving $500,000 to the 18-year-old child. You can make a better plan around that by having a living trust in place, because when you have a place, you can determine how our child is going to have and use the money even after you, by, for example, stating that at a certain age and stage, the child can have a certain amount. So, a better level of planning will be having a living trust in place if you have minor children. Another example that we're going to look at is if you have a blended family. If you have a blended family, it may be better for you to have a living trust drawn rather than a will. We find a lot of people have a boilerplate will. That's what I say. Will say everything I have goes to my husband, everything my husband has goes to the wife. When you have a blended family, a lot of people shortchange the children they have out of wedlock, because they don't make provisions for those children that were born outside of the wedlock. If you have a trust in place, you can make a better planning for those children so that you won't unintentionally disinherit them, so that you'll be able to make specific distributions or make certain types of trusts that will help those children that are not children born out of marriage. So a blended family is, when you have a blended family, look at having a living trust in place rather than having a will. Okay, the next thing is if you have problem children. If you have problem children, probably children that have alcohol issues or drug issues, or those who are not financially responsible, you may want to have a trust in place for them rather than just give things to them outrightly in a will. So that's another situation where you want to be able to make special provisions for them by having a revocable living trust rather than a will. If you have a business, whether an LLC or an Inc., then maybe you want to look at having a living trust rather than just a will. Because if you have a living trust in place, then your company provisions can be made for your company in having a living trust. And what you want or how you want things to be done after you with respect to the company can be stipulated in the living trust. There are a whole lot more. If you have a special needs child too, you may want to have a living trust, a special needs trust in place for them rather than just having a will. Many people create simple wills, and this may not necessarily answer all the relevant questions that need to be determined when you're planning extensively for your loved ones after you. I'll admonish you today with these things that we've spoken about. You may need more than a will. You may need to have a living trust in place, or whether a revocable or an irrevocable. For you to know more about having a revocable living trust rather than just having a will, you can contact an expert estate planning attorney. You can contact us at Ivy Law Office, and we will be glad to speak with you and to make a determination with you on whether you will need just a will or whether you need more than a will and you need a trust. So, on this note, we invite you to call our office 301 276 0887. We are at Ivy Law Office, and we practice Maryland estate planning. 301 276 0887, and we'll schedule you for a meeting with the attorney, estate planning attorneys, so that you can make a good determination for your family. You don't want to leave your family in conflict. You don't want to leave your family in a mess. You want to do the right things for your loved ones. So, in that note, you want to make the right decision on the best type of estate plan that fits your family needs. Thank you for watching today. We look forward to having a conversation again next week. If you like this video, please like, share, and subscribe to our YouTube channel. Like us on Facebook, and visit our website www.ivylawoffice.com and call us at 301 276 0887. Thank you On this note, too, I'd like to invite you to our upcoming estate planning seminar that will happen on March 10 and March 11. And it's going to take place at 6404 Ivy Lane at 6 p.m. on March 10, Friday, and at 10 a.m. on March 11. It's at the COP Conference Center, 6404 Ivy Lane. Look forward to seeing you there. And you can call those numbers 301-276-0887 to register and attend. Thank you very much and have a good day.